Hello, welcome to Board Game Bonkers. I'm Jay Sears, and this was a request of a video from one of our subscribers to the channel. And today we're going to talk about protecting your board games. So if you're a board game designer, or perhaps you're aspiring to be a board game designer, or perhaps you're looking for some advice and support to give someone else, well, you've come to the right place. This video is going to go through the basic aspects around copyright, trademark, patent, and protecting your ideas and your designs. Now, I want to be clear and start off by saying I'm not a qualified solicitor or lawyer. However, I have studied music law and I used to represent artists and write record contracts, so I have a good basis understanding of copyright. I want to be clear that I'm not qualified, and please do always seek legal advice for any information on these topic areas, and use this only as general advice and guidance. Don't use it as a legal format. However, I have taken a lot of information from the current Acts. I will cover the Acts and what it refers to within UK and US law, but again, please keep in mind I'm not a qualified solicitor or lawyer in these areas, so please do always seek legal advice. Now, with that out the way and those disclaimers, if you're looking for more content like this, please do consider subscribing to the channel, and you can be part of the community and let us know if there are any particular videos you would like to see in the future. So I'm going to start off by forming that as by talking about ideas and how they're protected. That will seek into copyright naturally, and then we're going to talk about trademarking, and we're also going to talk about patenting. I'm going to spend most of my time in copyright and give you different tangible examples so you can see how this works in practice. I will be going back in time to give you these examples, to give you some information about lawsuits and how that operates against the likes of Trivial Pursuit and what that looks like in practice. And also, we're going to discuss about Monopoly and Twister and how they have trademarked their board games and patented them as well. So, with that out of the way, let's dive straight in and talk about your idea. So you're a game designer. You have this idea for designing this game, but you're concerned about someone stealing your ideas. Well, I'm going to get into copyright in just a second, but ideas and facts are not protected, okay? So under copyright, and you'll find this in most countries, and certainly all that I'm aware of, that these are not protected. So I have an idea in my mind, and let's just say I have that idea, and somebody else, another country has exactly the same idea, and they get a board game to the market. Is my idea protected? No. Why? Because it's not in any tangible form, a medium form. Therefore, to represent whether you have evidence to say that that idea was yours and originated from yours. So let's just move forward and say I've got an idea, and I therefore write that idea down. Is that protected? Well, unless it's some tangible form of artwork, for example. If it's a written text and somebody else uses that text, then yes, it is protected. However, if somebody in another country writes down, coincidentally, exactly the same text as you, is that protected? Unless you can prove they have taken it directly from you, therefore no, because that's just coincidence. However, let's fast forward a bit and just say that you have noted down your tangible idea into a format that is designed into a prototype game. So your idea from your head is gone through into a physical form. You've written your rule book. Is that protected? Well, that idea is protected. But there are two different elements of copyright. So let's move on to copyright and understand how those ideas are protected under the laws. So I'm going to refer directly mostly to UK and the US, and you'll find some similarities to many other countries, particularly in the EU, when it comes to copyright. So I'm going to dive down into the computer. I'm going to read some extracts from some articles and the Acts to give you as much accurate information as I can. So before we get into that, I want to give you some two examples that gives you more of a tangible understanding about how copyright works. So there are two major lawsuits that were put in against Trivial Pursuit. Now, both of which went all the way to the High Courts, and they had inventions of the idea. So those ideas were stolen allegedly by Hasbro. So let's talk about those particular lawsuits to give you an understanding about how copyright may or may not work in law. So bear in mind that law has changed since these lawsuits were put in. And the first one is the Hitchhiker's lawsuit. That came out in 1994. But actually, the idea that was stolen was much earlier than that. So let me read the story to you. So David Wall said that he and a friend were picked up by Chris Haney, or Haney, it might be spelled or pronounced. Apologies if I butchered that. So while hitchhiking in the fall of 1979, so during the ride, Wall claimed to have told Haney, or Haney, details about a trivia board game idea he had. Details included the shape of the playing pieces and the pie piece tokens. Wall's mother even took to the stand and testified that she had seen Wall's drawings of plans for a board game that looked suspiciously similar to Trivial Pursuit. Unfortunately for Wall and his poor mother, those drawings had gone missing or had been accidentally destroyed. That case was upheld and thrown out, so therefore he didn't win any money. Now, let's go dive a little bit deeper into that. So you've got this idea. He's created this physical form. However, that physical form has got destroyed or has got missing, has disappeared. And he's there taken Hasbro to court to claim that they've stolen his idea. Now that shows that ideas are not copyrighted, but the tangible format that idea was on would have been copyrighted if he had a physical copy of that game to show and represent that they had copied his game and his ideas. But because he didn't have that physical, tangible medium format, he therefore had no evidence to support his claim. So that claim was thrown out of court. Let's move on to the next one, which is in 1984. So Fred Worth, and that was first his Trivia Pursuit, Fred created a book in 1974 called the Trivia Encyclopedia. So Fred looked through Trivia Pursuit and noticed that there were plenty of similarities between the questions in Trivia Pursuit and the questions in his trivia book. The creators of the game admitted copying from his book, but also showed how they copied from tons of other sources as well. This copying was declared research by the California courts. You might be thinking, well, hang on a minute. They've admitted to copying, blatantly copying from someone else, but claiming it's for research purposes, but still using it in their game. Now, if everyone involved where that work is copied from put that lawsuit together, would they have had a much stronger case? Arguably, yes. But I'm not a solicitor or a lawyer. But it just goes to show that even though they blatantly copied, they got away with it, claiming it was for research. Now, they've obviously found a loophole in the legal system, and I'm sure today, would that get away with it? No, probably not. But again, I'm not a solicitor or a lawyer. So that just gives you some examples in the practical world about copyright. So let's get into copyright and explain what that means, what it is. So we talked about our ideas and making it has to be in a tangible form. We've seen that. If it's not in a tangible form, it's really difficult to prove that somebody has stolen your ideas. So international copyright doesn't exist. Now, copyright does not protect ideas and facts. We know that. I've explained that. However, the Copyright Act in the UK, and I will come to the US in just a moment, does not allow making multiple copies of a single item. That's the same with the US as well. So you're allowed to make a single copy for your personal study purposes, so research or study, but you cannot make multiple copies, and then you cannot claim that what was somebody else's work as your own. So as a principle, a piece of work becomes automatically copyrighted. Now, once it's expressed in a fixed and tangible medium form, that is copyrighted. However, in the UK, it's automatically copyrighted. You don't need to do anything. But in the US, what you're advised to do to ensure that it's formally copyrighted is to register it with the Copyright Office. Otherwise, it's not formally copyrighted. In the UK, you don't need to do anything. You will find in the UK there will be companies trying to sell you their services to say that you can copyright your product or game with them. It's automatically copyrighted in the UK. You don't need to do anything. What people are advised to do, it's called the poor man's copyright, is that you send that game or written format or perhaps it's artwork to your self-recorded delivery. You do not open it, therefore you've got some evidence that it is copyrighted and that is your work. However, it is not formal in any UK law that will be upheld in court. So please keep that in mind. Because in the UK, it's automatically copyrighted. You don't need to do anything. In the US, you need to register it with the Copyright Office. Now, generally, names, slogans are too insignificant to warrant any copyright. However, we're coming to trademark in a moment, and we'll explain that certain slogans, names can be trademarked, but they're not copyrighted under what's called the works. Now, single phrases or headlines are unlikely to be protected. It's really difficult for anyone to copyright a phrase or a name. So let me give you some examples in just a moment in the terms of what percentage is copyrighted, and I will clear that in just a moment. So are board games copyrighted? Because that's why we're here. If I make a board game, is that copyrighted? Now, as soon as a board game is created in a physical or medium tangible form, so in the US and UK, it's protected under copyright. So it's known as your creative works. So you have your written works and you have your creative works as well, which is also in the form of any artwork. That may be in cards, it might be in the rule book, it could be in the board. Now, copyright does not protect mechanics or mechanisms of the actual board game. However, we will come into later and show you previously historically, we have had patents for board games that have been protected, but we'll go into that in just a moment. First, we're talking about copywriting and the works and the creative works, the written works. That is protected under UK and US law and many other countries in the EU as well. Now, copyright does not stop another person, from creating a board game with the same theme or mechanics as yours. So I could create the same type of game using the same theme and same mechanics, but using different artwork and different style of text. That's perfectly fine because the game is different. I haven't copied directly from your game. So mechanics, mechanisms, brown apple, green apple, and the actual game theme is not protected. So you don't worry about somebody stealing ideas in terms of the theme or a unique way of using the mechanic. That is not protected. If you're that concerned, don't post it anywhere. Now, when we come into copyright, it also doesn't protect the title of your board game. It's names, slogans, and general symbols or designs. However, when we come to trademarking, you can trade certain symbols and certain phrases and titles. As a general thumb rule, it is extremely difficult to trademark a single word, but they're not protected under general copyright through the works and creative works. Please keep that in mind. So what is protected? Well, the artwork's protected, known as the creative works. So your design of your board game. The cards are protected. Any illustrations in the rulebook is protected under copyright. And it can also protect some designs of custom components like meeples or miniatures, but it has to be custom designed, not generic. That is not protected under copyright. The text in the rules is copyrighted. That's called the written works. If it's original work, you haven't copied it or taken it from anywhere. If there's enough text on the cards, and I mean enough by referring to, for example, if you have a card that says discard one to take one resource, that is not protected under copyright. It's not substantial. However, if I have a narrative story on a card, then yes, that would be protected under copyright because it's substantial amount of text is on there. So you have to weigh up whether that is protected or not protected. Is it substantial enough? Is it too generic? You have to remember that when it comes to text on a card. We will come into later in terms of trademarking and patenting and work and what that looks like in practice. So I'm going to give you a myth. And there's a myth going around to say that, well, there's a 30% rule, so I can take up to 30%. There is no 30% rule. Some may refer it as to 10 to 30%. There is no percentage or rule in law under the US and UK acts that states how much you can take, copy, or rephrase or rework. So, drawings, websites, or other creative work, you run the risk of copyright infringement. So if you're blatantly taking and copying something, that's an infringement of copyright. So you're protected, as was stated, under the laws in UK and US from the works that you create, as long as it's on a tangible medium form. So let's talk about copying. So somebody's copying, what protection do you have? So there's no defined amount on how much you're allowed to copy, but the UK law states that non-substantial and fair use, but is not defined. So if you're copying someone, it has to be non-substantial and fair use. That refers particularly as well, any particular copyright is no longer copyright into public domains, i.e. if it's more than 70 years, for example, in the UK, then it becomes in the public domain. Therefore, you can use it freely and willingly. However, it must be fair use. You can't abuse it. Now, half of a book would be substantial, for example. One chapter would not. That's just copying. But if I'm copying that and passing it off as my own work, that's an infringement of copyright because I'm referring it to my own work. That's different to me copying something, getting permission, and quoting. That's completely different. Two tangible, different forms. So how much can you use as your own? That's a good question. Well, according to the law, there is no legal rule stipulating what quantity is okay to use without seeking permission from the owner or creator of the material. So, how much do I have to change in order to claim copyright in someone else's work? The bottom line is only the owner of copyright in a work has a right to prepare or to authorize someone else to create a new version of that work. Accordingly, you cannot claim copyright to another work, no matter how much you change it, unless you have the owner's consent. Bottom line is, do not copy. Do not pan off someone else's work as your own, unless you have permission to use that piece of work and you're quoting where the source came from. So another good question that might pop up in your mind is, when rewriting copyrighted articles or book in your own words, what percentage difference does it need to be considered unique content? So generally it's okay to get ideas and validate information. However, this needs to be worded in your own words. You cannot rewrite a book or article without permission from the copyright owner. Bottom line is, don't copy someone else's work without gaining permission. And please do not use anyone else's work without gaining permission to do so. If you're creating work on a board game, create your own original work. That automatically becomes copyrighted when it's on a tangible medium form. Therefore, making a prototype, for example, or perhaps you've written rules on a text document, that is copyrighted under UK and US law automatically. However, remember, in the US, you must also, for formal protection, register it with the Copyright Office. So let's talk about the creative works. Perhaps you're an artist and you're designing artwork, or you've made a mold, or you've designed this new meeple that's really unique and different. So how much do you have to change art to avoid copywriting? So we've got Leonard, for example. We've got different AIs that strip artwork from the internet and then try and recreate some of it, and then trying to recreate and make something that's available to the public. However, that is deemed as stealing because it's just stripping what's already existence. So there's no actual percentage by law and how much you change an image to avoid copyright infringement. There's nothing in law that states that you can take 5%, 3% of it and change a few things. Remember, it has to be substantial. So if you substantially change something, it looks completely different, well, that's fine because you substantially changed it. If it's too similar, then you're infringing on copyright. You have to keep that in mind. There is no 10 to 30% rule. That doesn't exist. There is nothing stipulated in law of how much a percentage you can take from another person's creative works, whether it's written, whether it's in photographs, whether it's in images, whether it's in a physical meeple format. It has to be original. Remember though, generic meeples that are generic are not copyrighted in any way because they're too generic, but something that's more unique and completely different can be protected. So let's now talk about trademark. Now we understand copyright and have a better understanding of how that works in practice. Now trademarking is something that you trademark, a slogan, a phrase for example, and we're coming to some tangible examples in board games in just a moment. But trademarking only applies in the country it was applied for. But you can use what's called the Madrid system, and that applies to over 130 countries. What is the Madrid system? Well, that means it's just one application. And I will put a link to all these articles and posts that I've read in the description down below. You'll be able to read this particular Madrid system and one of the blog posts I wrote on copyright and trademark protection, which is quite a few years ago, but it's still relevant today. So I'll put a link in the description down below. Now, trademark is used to protect the symbols, words that I mentioned, phrases. Companies use this. For example, McDonald's, Kellogg's, all these big, huge brands, Hasbro, they use trademarking because of big, huge companies. Now, the question is, as a small game designer, do you need to trademark? Well, no, it's really a waste of time. Are you going to sell millions of copies? Then what's the point? Do you want to waste money? You may as well flush it down the toilet. So you've got to think about that. You usually find trademarking in big companies or companies that are fairly medium or large in size, not small companies or individual game designers starting off. It's really not worth it unless it's something completely unique and different. And I mean completely unique and different, which is almost impossible these days. So Monopoly, for example, the trademark designed for chance spaces, the car and free parking, the Jake and the jailbird design, the police officer and the goat jail, that's all trademarked under Monopoly, Hasbro. However, that came from originally patenting that particular board game. Now, I'm going to tell you now, before we go into patents is extremely difficult to obtain for board games. Remember, the mechanisms/mechanics are not protected. You can't protect them under any law. It's almost impossible. So, there was a case as well with Catan where that trademark was infringed upon. Again, that's in one of my blog posts that I wrote. I'll put the link in the description down below. And the tap symbol for Magic the Gathering, that often comes up. Is that protected? Well, originally they had a patent, and I'll explain that that's expired, and we'll go into a bit more detail in just a second. But that is registered as a trademark, that tap symbol. But the mechanism of exhausting a card is not protected. So that's why a lot of game designers will use the concept of exhaust a card, which really thematically makes more sense than tapping. I don't like tapping. I may as well tap my feet because it just doesn't really make sense in tapping a card. Exhausting makes more thematic sense. Now, are you protected if you don't trademark? Because that's the ultimate question. If I don't spend money to trademark, well, in the US and UK, if you have not registered your trademark, you're still protected under common law. So somebody tries to pass over your logo and board game as their own, then you're still protected under common law. Remember, trademarking is specific for logos, perhaps a name, a specific symbol that's not too generic, or a phrase. That's trademarking. Let's now talk about patents, because patents are quite interesting. Do you need to patent a board game? No, I'm going to be upfront. You do not need to patent a board game. Do not waste your time. It is almost impossible these days. But I'm going to give you some examples where board games were patented, and some still are, but they were historically put in place. So a patent only applies to the country that is issued at. Keep that in mind, just like trademarking and copywriting. So patent protects things that are made or used. It's something tangible. Think of a light bulb. Something that's original. Isn't an extension of something. It's completely new. So are board games patented? Can you patent a board game? You can. However, like I said, you need to go back in time. It's extremely difficult to have any board game patent these days. So a famous example is Monopoly back in 1935. Another example is Magic the Gathering. Let's talk about Magic the Gathering. So in 1995, the Wizards of the Coast, and I'll put the link in the description for this article down below, they filed a patent application for what eventually became a US patent number. I'm not going to name the number, but it was essentially 332 patent, which detailed broad MTG game rules. So the patent covers a method of playing games with two or more players, with deck construction, shuffling, drawing, playing, discarding, and general turn sequence in accordance with undisclosed game rules. Keep in mind that this patent no longer exists. It also covers turning cards into to indicate a state of use, which is known as tapping. The patent does not go into detail concerning the actual 5 phases of play. Though some games like Monopoly and Twister have patents, and it has become more challenging to patent games under the rule, 35, 101, the section of US law that defines patent eligible subject matters. Now, it's very similar to the UK. It is very, very difficult to patent a board game, very difficult these days. In the wake of Alice versus Bank in 2014 Supreme Court in the US, Alice articulated limits on patent eligible subject matter, and since then courts have interpreted sections 101 to place stricter limits on patent abstract ideas. So as you can see, it's almost impossible to patent a board game these days. The patent for Get Magic the Gathering doesn't exist. It no longer is in place. How to have trademarked certain things such as the tapping. So please keep that in mind, that patent is almost impossible. So what does a patent do? What does it give you? What does it actually protect? Well, if it's new and it's useful and non-obvious, you can patent something. So is the board game new? Is it obvious? Non-obvious, I should say. And is it useful? Well, if it meets those three criteria, you can patent a board game. So are board games fitting into that category these days? All three? No, pretty much impossible these days because nothing is that unique. Now, will that protect your game if you can patent it? Well, yes, it will. It'll stop anyone copying it or taking any ideas from it. However, it's almost impossible to do these days, so I wouldn't waste your time or money. In fact, I'd forget completely about patenting any of your board games. Now, there was an important ruling, as I said, in 2014. Now, it sets the precedent for the organising of an abstract idea and to set rules that is not patentable, so therefore making it almost impossible. So that was regarding software that, in case, can also be used for game mechanics. It is impossible to protect and copyright any mechanics in a board game. It is impossible. Think about it. If you design a working placement game and then someone else designs it, but they can't because you patented that mechanic, how many games would be released? Very few. Very few board games, which is why generally genres such as film genres, board game themes, board game mechanics, they are not protected because it limits the creativity and stifle that development of board games. So Twister is a good example. Now that is patented because the rules of the game is protected in terms of the playmat and how that operates. However, patents only last for so long. They will eventually have to be reissued, and as laws change, it becomes more difficult and stringent on what is protected. So that brings us to the end. We've learned and understood about copyright, trademarking, ideas, patents. But the bottom line is my game protected? If you have an idea, as long as it's on a tangible medium form, yes, it is protected under law. But of course, always seek professional legal advice for more detailed answers in this subject matter. I hope you found this useful, and I hope it gives you a lot of insight. As always, the links will be in the description down below for more information in detail on copyright and trademarking. Bottom line is, don't waste your money on things you don't need to spend money on. Your game is already copyrighted, so if you put it in Board Game Geek, if the rule book is there and the game design is there, that's copyrighted, it's protected. But if your idea is written down, that's just an idea. If it doesn't formulate the graphic design, if it doesn't describe the rules and gameplay and how it operates, then it's not protected. You need to have it in some tangible medium form. So keep that in mind when you're designing board games. Somebody tries to take that and use it as their own, and you have evidence, then they could be infringing on copyright. Hope you've enjoyed this. I'd like to thank you for taking your time and watching this. I hope you found it useful and insightful. And please keep in mind, I'm not a qualified solicitor or lawyer. And please consider subscribing to the channel if you haven't already done so for more content like this. And let us know in the comments down below. Is there anything I've missed? Is there anything you can recommend? Until next time, take care.